Back now in public session for session 2. Welcome back everybody and thank you for being here. Can I remind members and witnesses regarding mobile phones to please ensure that they're switched off for the duration of the hearing, and also to remind members that we will start promptly on time as we do every week, so just remind you that. This is our second session of hearings of the Joint Committee, which will be carrying out over the next 3 days to discuss the implementation of the government decision following the recent publication of the expert group into matters relating to cases ABC versus Ireland. In this regard, I want to welcome to our session Dr. Rhona Mahony, Master of National Maternity Hospital, Dr. Sam Coulter-Smith, Master of Maternal Hospital, and Dr. Mary McCaffrey from Tralee General Hospital in Kerry, Kerry Hospital, Tralee. Kerry General, you're more than very welcome to our meeting. And before we commence, can I remind witnesses regarding position and privilege that witnesses are protected by absolute privilege in respect of the evidence you are to give to the committee. However, if you're directed by the committee to cease giving evidence in relation to a particular matter and you continue to do so, you're entitled thereafter only to a qualified privilege in respect of your evidence, and you were directed only evidence matter connected with such a matter this business to be given, and you're asked to respect the parliamentary practice effect that where possible you should not criticise nor make charges against any person or persons or entity by name or in such a way to make him or her identifiable. And members are reminded of the long-standing parliamentary practice or ruling of the chair to the effect that members should not comment on, criticise or make charge against a person outside the House or an official either by name in such a way to make him or her identifiable. So with that I will ask Dr. Mahony to make her opening remarks, please. You're very welcome.
Thank you. Deputy Buttimer, members of the Joint Committee on Health and Children, and ladies and gentlemen.
Understand you may just ahead. Thank you.
Thank you.
Thank you very much.
Just to say that I'm very pleased to accept your invitation to attend today. I wish you every success in addressing what I think is the most important and most complex issue, and I hope that I will be of some assistance. It's my belief that we are all here today with the primary objective of preserving life. By way of introduction, I am the Master of the National Maternity Hospital in Dublin. I'm a practicing obstetrician and I'm also a specialist in fetal and maternal medicine. That means that I help care for women whose pregnancies are complicated by either maternal or fetal disease. The National Maternity Hospital is one of the busiest hospitals in Europe, and it delivers over 9,000 babies annually, or 1 in 8 babies in the state of Ireland. We are a tertiary referral centre, which means that we looked after some of the most complicated pregnancies in Ireland. In addition to our own hospital population, we look after women referred to us from other obstetric units around the country. These women require additional expertise in dealing with a variety of complications that may arise either de novo or as a result of pre-existing maternal disease. The primary reason for my presence today is to help you understand why it is that we as doctors need enhanced legal protection in dealing with clinical situations where a pregnant woman may die and where treatment to save her life may include termination of pregnancy. I wish to make one thing very clear today. If there is any chance at all that a baby will survive at the threshold of viability, every effort will be made to save that baby. That must not be at issue today. Regularly, we look after babies at the threshold of viability with excellent result by international standard. Our neonatal intensive care is a national resource which cares for babies born as early as 23 weeks gestation and who weigh as little as 500 grams, even less in some cases. At the moment in Ireland, doctors practice medicine relating to pregnancy with a degree of legal uncertainty. It is as far back as 1861 that the Offences Against the Persons Act, specifically sections 58 and 59, decreed that abortion in Ireland is a criminal offence, punishable by a life of penal servitude for both women and her doctor or anyone who assists her in procuring an abortion. This law remains today. It was to be over 130 years later before the Supreme Court judged that termination of pregnancy was admissible in the very rare circumstance of a real and substantial risk to the life as opposed to the health of a mother. As we all know, the risk to life in this case was the risk of this young girl taking her own life because of her distress at being pregnant. 20 years later, the anticipated legislation that might have come from this has not been enacted, and therefore there is a degree of legal uncertainty in how we interpret the Supreme Court judgment and whether or not the Offences Against the Persons Act is in fact precedent. It remains law. In the meantime, it's quite interesting. We have passed a variety of referenda which allow women access to information on termination of pregnancy outside this jurisdiction. Women are allowed, we've had a referendum that allows women travel to alternative jurisdiction for termination of pregnancy, despite the fact that such a thing remains a criminal offence within this country. We've twice held referenda to remove suicide ideation as an indication for termination of pregnancy, but we have not yet managed, I believe, to address the legal uncertainty surrounding termination of pregnancy in the very narrow, rare confine and context where we believe there's a genuine risk to the life of a woman, where a woman may die as a complication of her pregnancy that could be saved by terminating her pregnancy. So in very rare circumstances, doctors are faced with the task of making highly complex clinical decisions based on medical probability, but without the luxury of medical certainty. It is imperative that we have flexibility to do so, to make decisions based on medical fact. It is imperative that we have legal protection to do this. The state demands of us that we save life wherever we can, and we must do this. This is our job. If a woman is critically ill, and it is very obvious that she is likely to die, and she will be saved by intervening and treating her, and that treatment involves interrupting or terminating the pregnancy, we will not hesitate to do so. And society and women may be absolutely reassured that we will not hesitate to do so. The difficulty arises when the risk to life is not immediate. And so, for example, a woman who has a serious underlying medical disorder, she may be sitting in front of you now, but the additional burden of the physiology of pregnancy on organs that are already burdened and already challenged may pose a very significant and substantial risk to her life. Doctors need to have the flexibility to make appropriate clinical judgment, not based on ideology, not based on philosophy, but based on medical circumstance. That is what the state demands of us. And you know, we must acknowledge that very tragically, sometimes women die during pregnancy. In fact, about 8 women out of every 100,000 maternities in Ireland die as a result during pregnancy. Some of these cases may occur, women may die either because of direct pregnancy complications, or they may die from totally incidental causes like a road traffic accident, or they may die of indirect causes. For example, they may have a serious underlying morbidity. The addition of pregnancy may such challenge her that she may die. And in fact, if we look back at maternal deaths, this country has recently produced a triennial report into maternal deaths in Ireland between the years 2009 and 2011. There were 6 deaths arising directly from pregnancy complications, but double that number, 13 deaths arising in women who had pre-existing medical disease. 5 of these women had pre-existing cardiovascular disease, 2 of these women died of suicide, 2 of these women died of flu, and a variety of other medical causes, including liver disease and lung disease. Interestingly, however, it is my experience that in many cases, women with serious underlying medical disease will choose to continue their pregnancy in the knowledge that they may die. In other words, women will risk their own lives to reproduce. However, some women faced with a significant risk of their own mortality will not wish to continue their pregnancy. And this brings us to the very difficult issue of defining what is a substantial risk to life during pregnancy. 10% risk, a 50% risk, an 80% risk, a 1% risk of dying. The interpretation of risk is not the same for all people. And you know, a woman herself will have a view as to what is an acceptable risk of her dying during pregnancy. Her opinion deserves to be afforded consideration. Clinical flexibility supported by law is required. Doctors must be able to make sound, common sense medical decisions based on medical condition and medical circumstances, not ever on ideology or philosophy. But they must be protected in the law to do that if they are able to carry out their job to the best ability. And what doctors want to do, and make no mistake, is to preserve life. This is all about preserving life. Over the last few months, we've listened to a wide variety of opinion. Some of this opinion has been extreme and absolute, at times unhelpful, and I would argue at times even misleading. I believe this forum will hopefully provide an opportunity for informed and mature debate. I believe the outcome of your important work will underpin society's wish to protect life as far as possible. Perhaps the most controversial issue, and I bring it up now, is that issue of death during pregnancy as a result of suicide. Attempts have been made to confuse the risk of death from suicide by quoting UK figures relating to death from mental disorder, all mental disorders, not specifically. We are talking here specifically about the very small and tiny number of women who present wishing to take their life during pregnancy. Now, I'm not a psychiatrist, and I absolutely appreciate that you will be addressed later by specialists in the area of psychiatry, and of course, I defer to them. But could I just say, as a woman, I'm offended by some of the pejorative and judgmental views that women will manipulate doctors in order to obtain termination of pregnancy on the basis of fabricated ideas of suicide ideation or intent. There also seems to be an assumption that psychiatrists are unable to assess the issue of suicide ideation, something they do every day in their clinical practice. I don't believe we have the right to absolutely dismiss the risk of a woman taking her life during pregnancy. Women will occasionally, we know that women will occasionally, rarely, but they will occasionally take their own lives during pregnancy. Women who are so distressed that they will consider taking their own lives, they need to be listened to, they need to be believed, and they need appropriate medical care. That will not necessarily include termination of pregnancy, but in a small, tiny percentage of cases, it just might. Finally, let's remember the women and children who've brought us here today, and yes, I use the word children. The X case. Let nobody in this room forget the circumstances of this case. This is the story of a 14-year-old child who was raped and who found herself pregnant and was so distressed by her circumstance that at the age of 14, she wished to take her own life. Let nobody forget her because she's real. Thank you.
Thank you very much indeed. Thank you. And I want to now call on Dr. Sam Coulter-Smith to make an open presentation.
Thank you, Chairman. I'd like to echo Dr. Mahony's thanks for your invitation to come to speak to you today, and I hope that we can be of some assistance in your work. I suppose, first of all, just to introduce myself, Sam Coulter-Smith is my name. I'm Master of the Rotunda Hospital. I'm in my 5th year of a 7-year term. The Rotunda Hospital is the oldest maternity hospital in the country and one of the oldest maternity hospitals in the world. Many of the comments that Dr. Mahony has made in relation to the National Maternity Hospital would also be applicable to the Rotunda, so I won't repeat all of that. But I think it's important to recognise that the Rotunda, in the Rotunda we look after about 10,500 maternity patients annually, and this
just for members, there is no script for this particular presentation. Just in case members are wondering. Okay, thank you.
And this accounts for about 12% of the births nationally. We're a tertiary referral centre for both sick mothers and for sick babies. We jointly manage maternal morbidity cases with our colleagues from the general hospitals. In our situation, it would be mostly the Mater and Beaumont, but also other hospitals as well. Just to put some figures on things and to put things into context. Of the women that we look after, we would have about 40 very, very significantly sick mothers with life-threatening issues annually. And we, as I said, we jointly manage these cases with our colleagues, mostly in the Mater. It's important to recognise that we only have access to intensive care facilities in the Mater Hospital, which is about 400 yards away, and that's not appropriate in this day and age. On average, we would have approximately 5 or 6 cases a year where interruption of the pregnancy would be required to save the mother's life. The range of conditions and the time scale in this sort of situation would be a case of maternal collapse, where some sort of immediate intervention would be required, where the mother's life was at risk with something like cancer or significant cardiac abnormalities such as maternal disease. The risk would obviously be not quite so acute, but the risk is definitely there. And then we have situations where the mother's life is at risk because of complications of pregnancy, such as infection. And in that situation, where there's no prospect of the baby's survival, then obviously intervention has to be made. Rhona's already alluded to the number of maternal deaths in the country. Most of the big maternity hospitals would expect to have somewhere between 0 and 3 maternal deaths a year, and that would equate to approximately between 9 and 11 in 100,000 cases. The causes of death would include epilepsy, thromboembolism, breast cancer, uterine rupture, hemorrhage, and then accidental death. I'd like to turn my attention, if I can, to the issue of maternal health, mental health. And nationally, we have 3 specialists who subspecialise in the area of mental health in pregnancy, and all of these specialists are in Dublin. Mental health issues complicate somewhere between 10 and 15% of pregnancies. So they are one of the commonest complications of pregnancy, yet they are one of the most under-resourced complications. Life-threatening mental health issues are rare. Suicide in pregnancy, the incidence of suicide in pregnancy would be of the order of 1 in 500,000, and that's based on UK figures. We, I think, cannot be sure of the numbers who will feel that they have a significant risk of suicide, as many of the patients who currently have suicidal ideations may not interact with our maternity services or our mental health services, and may in fact travel to the UK without accessing any of the services in this country. So I think it is important to realise that it is very rare for a woman to claim that she is suicidal in pregnancy and wants a termination of pregnancy. I think there are a number of issues that I would like to highlight. And firstly, it might seem a small point, but I think it's hugely important, and that is the terminology that we use when we talk about this subject. Some people will use abortion, some people will use termination of pregnancy. I think it's important because there are huge, it's of enormous psychological importance to a woman who's having her pregnancy interrupted for a life-saving procedure. Whether we call that an abortion or a termination of pregnancy, I think is important. I think there is the potential for a very significant impact on existing services. Our maternity services in this country at the moment they're all demand-led, and they are barely coping with the existing demand, on the service. We don't know what the demand is coming down the line. We don't have the infrastructure, the staff, or the resources from an obstetric point of view or from a mental health point of view to deal with this new component of a service that we may be asked to provide. I think the legislation and regulation is important. I would welcome the Cabinet's decision on legislation and regulation. I think that the legislation needs to be short. I think it needs to take into account future developments within medical practice. And I think there needs to be a degree of flexibility within that legislation to deal with the wide variety of clinical scenarios that we face. I think in terms of regulation, there needs to be a suitable number of qualified doctors involved in a decision to terminate a pregnancy. Those doctors should be on the specialist register. There should be opinions of at least 2 senior obstetricians, plus the opinion of whatever specialist is involved. So if it's a mental health issue, then obviously a psychiatrist has to be involved. If it's a cardiac issue, then a cardiologist needs to be involved, and others as well. In terms of where these procedures should occur, I think it will depend on the clinical scenario, but I think most institutions who provide maternity services should have the ability to provide this service, bearing in mind that some of the smaller hospitals won't have the appropriate mix of specialties to deal with it, but and a referral pathway needs to be made for that situation. I think there needs to be an appropriate appeals system with appropriate access to legal opinion and access to the courts where necessary. Just briefly, just to turn to the area of conscientious objection, I think it's important to realise that when we're talking about this situation, we're talking about when a mother's life is at risk and she's at risk of death. And in that situation, obviously, conscientious objection becomes a lesser issue. I think I'll leave it there, and obviously you can come back to any of the other issues.
Thank you, Dr. Smith. Thank you. And now I want to welcome Dr. Mary McCaffrey from Kerry Hospital, Tralee, who's also joined with Mr. John Monaghan from Bhuinneain as well. So, Dr. McCaffrey, you're very welcome.
Cathaoirleach and members of the Oireachtas Health Committee, I'd like to thank you for the invitation to speak here today. I understand that the purpose of the invitation was to gain some insight into how proposed legislation might impact on smaller maternity units. Of the 19 maternity units in Ireland, 12 are manned by, personed, whatever phrase one uses, by 3 consultant obstetrician gynaecologists supported by junior staff and midwives. So there are 12 units of that size in the country, and approximately a third of all babies born in Ireland every year are delivered in units of that size. In putting this presentation together, I really am only a conduit for the views of a large number of consultants around the country, as I would have consulted with a lot of colleagues in similar sized units. And we've calculated out that of the people that were involved in this process, we have about 280 years of obstetric experience under our belt. So we have managed quite a large number of patients, albeit in smaller units. It would be important for us that the legislation that is finally passed would be workable and practical, that it will work equally in all maternity units in the country, that it will work for all medical practitioners, that all medical practitioners who practice in this country as obstetrician gynaecologists would feel well protected under the legislation. But most importantly, that all patients, regardless of where they deliver their babies or are cared for from a maternity point of view, would be treated equally and that the system would work for them. I thought that it would be important for people to maybe understand the day-to-day workings of a 3-person maternity unit. On each weekday, you have 3 consultant obstetrician gynecologists in your maternity unit. There will be 1 on-call consultant obstetrician, and they will be looking after all emergency procedures, theatre, labour ward. Their 2 other colleagues will be carrying out theatre lists, operating, doing outpatient procedures or whatever. So they will be within the hospital during the normal working days. Out of hours, after 5 o'clock, say from on Monday to Friday, the on-call obstetrician is the only person available within the hospital on site until 9 a.m. the following morning. At weekends, from 5 o'clock on Friday, and in some situations from 1 o'clock on Friday until 9 o'clock on Monday morning, that 1 on-call obstetrician is the only on-call emergency consultant available in that hospital. Obviously, they have a team of support staff, but they are the only senior obstetrician in the hospital. And I think that's a very important point to make in terms of staffing levels. So there are times when there is no immediate access to a second person on call in a maternity unit. Most people would be acutely aware of that. If they needed to collaborate with a colleague, they would endeavour and strive to get that contact by telephone or whatever. The other point to make is that at times of annual leave, that locum consultants who are temporary consultants, agency staff or whatever, are brought in to cover that consultant. So they would not be part of the regular staff in the unit, but in general, most consultant obstetricians in smaller units would endeavour to employ a small core number of people who are familiar with the unit, and we would use the same people in general all of the time. and they would in general be people that we would consider to be trained to the same level as ourselves. So that is how the staffing levels work in the smaller maternity units in the country. We then looked at the decision-making process for the various categories of patients and how we felt they pertained to our practice on a day-to-day basis. And I just will reiterate, this is me being a conduit for the views of a large number of people, and I'm trying to put these views together in the most objective fashion for you. We looked first of all at women presenting with serious medical conditions which people felt were the pregnancy itself would put this woman's life at risk. The most obvious example is probably serious heart disease, very serious heart disease. We felt that in general, these women would already be under the care of a specialist cardiologist or other physician in another hospital, in a tertiary referral centre in Dublin, Cork, Galway, whatever. We felt, and it was the unanimous view of everybody I spoke to, that these patients were best managed in that tertiary referral unit, and that we would not be involved in decision-making, signatories, but because we wouldn't have the expertise as obstetricians in a smaller unit to decide whether this woman's pregnancy was compatible with life or not. So she would be travelling to, and probably will already be involved in some centre such as the Coombe Women's Hospital have a medical clinic where they have 3 consultants and specialise. They may be going to Rhona's clinic or to Dr. Coulter Smith. But we felt that in general these were not a group of people that we would be involved in the smaller hospitals. Even if they presented on our doorstep for whatever reason as an emergency, they were on holidays for the weekend, it would be inappropriate for them to have any procedure performed because we wouldn't have the backup of cardiac anaesthetist or whatever, that they would be stabilised and transported back to the place that would best serve their needs. The second group of women we looked at was the group of women presenting with suicidal ideation or intent. In discussing it among the group, I personally have no knowledge of ever having cared for a woman where very specifically she wanted to end her life because of the pregnancy specifically. And in my pursuit of information over the last week or so, I've been unable to identify any other consultant who did know of such a woman, which backs up the information we've already got, that it is an extremely rare situation. The consensus among my colleagues were that we did not feel as obstetricians in a medium-sized maternity unit that we had the expertise to be involved in making a diagnosis of suicidal ideation or intent, that we didn't have the expertise to decide that this woman's pregnancy should not continue, and we felt that that diagnosis and the signatories therein should be performed and carried out within the psychiatric services. We're then down to the issue that if 2 psychiatrists, or whatever number of signatories are finally decided, say that this woman should have her baby delivered early, or the fetus delivered early, in the interest of our health, should this happen in a smaller maternity unit? And a number of issues came up in this. Yes, we felt that medically, if one looked at the medical services, yes, we could and had the facilities to do this. There were a significant number of reasons why people felt it shouldn't happen in a smaller maternity unit. And a lot of the members of the committee here will know, you represent small rural areas, how difficult it can be in a small rural area to remain anonymous. And we felt that the issue of stigmatisation of women might occur, that anonymity would be an extremely difficult issue to maintain. Some colleagues had issues with regarding skill base because it was a procedure they had never been involved in and did not wish to be involved in the future. And not an issue for this committee today, but I have to take the opportunity of saying it. In the smaller maternity hospitals, the gynae services and women's health are becoming the Cinderella services of the health services in general. There are a significant number of maternity units in the country. Sorry? No, but I'm just saying we do not have the gynae wards to put these women in. A pregnant woman who is already fragile because of her condition would be put into a ward with pregnant women who are having babies. So we did not feel that in a number of units this was appropriate. We then looked at the the obstetric emergencies, and the consensus of the group was this is something that we carry out on a day-to-day basis in our practice. We're looking at women with severe infection, severe sepsis, severe hemorrhage, a condition called severe fulminating preeclampsia, HELP syndrome. We manage this on a regular basis as obstetricians in smaller maternity units. We decide on occasions that we will transfer them out to bigger hospitals. In many circumstances, it's inappropriate to be sent 70, 80 miles in an ambulance, and in those circumstances we stabilise, we manage the women ourselves, and this is what is regular practice. We felt this practice should continue. We felt that most people, as best practice, do consult with other colleagues in managing complex cases, and that would be the practice they would continue. We weren't really convinced that a formalised signatory process was necessarily appropriate. We felt that babies going to be born on the cusp of viability, and this issue has come up already today about what is extreme immaturity. And you're looking at babies that are going to be born at 23, 24 weeks. The dates might be wrong, a woman's dates might be wrong. That obviously they would be better served in a maternity unit of a larger size, that if it was unsafe to transfer the women, we would utilise the services of the neonatal transport teams that already exist and serve the rural areas very effectively. And lastly, I wanted to deal with the issue of conscientious objection. One of my colleagues is aware of a situation in the UK, where 9 out of 10 anaesthetists, they obviously put patients to sleep, would not anaesthetise for terminations of pregnancy. So the conscientious objection clause is something very important to the hearts of a lot of people here. The current medical council guidelines facilitate that. There was concern about one sentence in section 6.9 of the expert report, which states most jurisdictions accept that an individual's right to conscientious objection is not absolute and has limitations. All of my peers accept that they will always do what's best for a patient in an emergency situation, but someone has the right to a conscientious objection, and that has to be respected. I have worked in the UK. Everyone I've spoken to has worked in other jurisdictions where termination of pregnancy is performed, and everyone's right to a conscientious objection has been respected elsewhere, and it would be absolutely important for us that that would also happen under future legislation here in Ireland, and that nobody in their job or in their future job prospects would be discriminated against. Thank you for taking time to listen.
Thank you very much indeed to both Dr. Mahony, Dr. Coulter and Dr. McCaffrey for their presentations. There now is 60 minutes of questions from members. Deputy Keller.
Thanks, Chair. Just to welcome the witnesses here. At the outset, I just want to make some observations and pose questions. Dr. Sam Coulter-Smith pointed out that, you know, you would be concerned about the increase. That you would be concerned about the increased demand on maternity services. You already said they're demand-led, and that in the event of legislation coming forward, you would be concerned that that would put additional pressures on the maternity services. Now, the question I have to ask is in the context of between 9 and 11 maternal deaths per 100,000 a year. Where do you see the increase in pressures on the maternity services in the event of legislation being passed and regulation being passed to facilitate terminations, in view of the fact that they would be very extreme cases and we would be within the parameters of Article 43.3 and the X case itself? So I'm just a little confused on that particular issue. On the issue of suicide ideation and suicidal tendencies, again, it has been elaborated on that this, in effect, is in very limited circumstances, and in fact that some consultants have never encountered a case where suicide was being contemplated because of pregnancy. And that's certainly something that, you know, other people have varying views on, but I think it's important that it's said by a very eminent obstetricians present here today. On the issue of conscientious objection, this has been referred to on a couple of occasions, but I'm just wondering about this particular issue of conscientious objection. Should it be public in advance of a person actually, you know, employing the services of a consultant, obstetrician or gynaecologist, that they would be made aware in advance of the fact that this particular person has a conscientious objection to carrying out a termination or an abortion? And I think that would be an important thing to sort of elaborate on, because people may have varying views as to whether or not you know, the patient should be informed in advance when they're taking on the services of a consultant, or if they are deciding to attend a particular hospital. And would it also be important that people who have a conscientious objection, in the event of legislation being passed, I may say, that they would be obligated to inform the employer as well when taking up positions of contract. Because I think that would be important, that in view of the fact that the Irish Medical Council has said that its patients come first, that they would be entitled to that information when they would be taking on the services of a consultant or a hospital, or at least finding out what the ethos of the hospital is.
Thank you, Deputy. Deputy Keevan O'Quillan.
Good and I'd like to join with you in welcoming our guests here this morning, and I thank them for their respective contributions. Just to pose a couple of questions. I note, Dr. Mahony, in your submission, you've made the point that it's very important that medical practitioners and women are afforded legal protection to allow for appropriate flexibility to make professional clinical decisions based on medical probability of risk to life. And I think one would understand from that that such provision would, of course, include all situations where certainty did indeed exist, but accepting the point that the probability would be the criteria in which the decision would be made. In that regard, do you believe, I mean, the expert group have indicated that the state are obliged to, and I quote, provide precision as to the criteria by which a doctor is to assess that risk. I take it that you believe that greater precision is achievable. And to what extent do you believe that that precision is possible given all of the complexities that legislation and regulation can present? I also would like to ask, if a woman's life is at risk, or the probability, and if I can ask both Dr. Coulter-Smith and Dr. McCaffrey to consider this also, if a woman's life is at risk or the probability has been professionally asserted, how would you envisage the independent review system functioning? Surely it would need set specific timeframes on its functionality. There is a lack of clarity on that matter. We raised it this morning with representatives of the Medical Council, and I'm anxious to know, have you views, ideas in relation to that particular aspect of the expert group's recommendations? And if, just lastly, if in any of your respective experiences, and I just ask it of all three, if I may, regarding sections 58 and 59 of the 1861 Act, we know that they remain in force with their absolute prohibition and the associated serious criminal offences thereby. In your experiences, in your respective experiences, has the fact that this remains in situ, has it at any time, to your knowledge, impaired or impacted on the decision-making of fellow professionals in your particular area of responsibility, obstetrics and gynaecology?
Thank you, Deputy. Deputy Matty McGrath.
I too want to welcome our guests and thank them for their enlightenment so far. I want to ask a number of questions, and the first one is, if legislation is introduced for termination of pregnancy in line with the X case, including where the risk to the mother's life is her own threat of suicide, do you think that this will increase the number of abortions? Will it change medical practice in any way? And number two is that abortion has never been considered an appropriate treatment for suicidality and has never been carried out by doctors in Ireland on this basis. Do you think that the obstetrical and gynaecological profession would be happy to carry out terminations which are prescribed by psychiatrists? A recent September 2012 symposium on maternal healthcare in Dublin concluded that abortion is never medically necessary to save the life of a mother. Are they wrong in that case? Thank you.
Thank you, Deputy McGrath. And finally in this session, Deputy Conway.
Thank you very much, and thank you to our speakers for their contributions to this part of the hearings to date. I suppose some of the things I wanted to raise are maybe following on, ironically, from Deputy McGrath's points in relation to how, and I think that what the point was made about how substantial risk of mortality is to be assessed. You know, because what are we talking about here? There's a lot of talk about suicidal thoughts and self-harming. But what if a mother has a long-established mental health problem?
Because oftentimes, I mean, we know of the proliferation of mental health difficulties throughout the country. People who are on severe medication regimes in relation to bipolar disorders, in relation to schizophrenia. And I, from my limited knowledge of working in the area as a social worker, know that often women are encouraged to give up their medication regime because they can no longer take it because of the pregnancy. And does that not increase the substantial risk to the life of the mother? I know the question was also asked by my colleague Senator Crown earlier this morning about, you know, and he probably would be able to answer this better than I, or put the question better than I, but in relation to where a woman is diagnosed with cancer and she cannot receive the treatment that she needs to save her life because she is pregnant. I'd like to know a little bit more about that, because these are the real life situations that women find themselves in. These are the real choices that women are faced with. Difficult, difficult choices. And I would really like to know from the people who are working on the front line how we go about ensuring that we can make this clear for women, first and foremost, and secondly, of course, for yourselves, the practitioners. Again, I come back to an issue that was raised by my colleague Deputy Kelleher about conscientious objection. We have seen, unfortunately, in this country in the not so distant past, where a young girl was to be forbidden from attending a particular school because she was pregnant and because of the ethos of that school. Now, I would ask the question about our hospitals and their ethos, and how that may have a restrictive impact in relation to the kind of health care that is required by women to save their lives.
Deputy. Dr. Mahony, Dr. Smith, Dr. McCaffrey, whoever wants to start first.
Great. Thank you.
We have 4 other speakers in this session who've indicated already, so just to be conscious. Thank you.
So just in an effort to answer all the questions, and I hope I do, and please feel free to pose any further questions if I haven't addressed the issues. But Deputy Kelleher, in regard to the numbers, we've discussed the concern that perhaps if we are to legislate for the termination of pregnancy in order to save a woman's life, that this will have a major impact in terms of numbers. I don't believe this to be the case. We are talking about a tiny proportion of women who we believe will die if we do not terminate this pregnancy. This is an extremely rare scenario. Nobody is talking about opening floodgates or creating a situation where we'll be performing many terminations of pregnancy. The risk of death in pregnancy is extraordinarily rare, but it does exist. So I don't believe this particular issue gives rise to concerns over particular pressure on services and numbers. These cases are very rare. Again, with regard to conscientious objection, we're talking about women who might die. I'm a doctor. My duty is to save life. I don't object or conscientiously object in my duty to save life. We are not talking about broad issues surrounding termination of pregnancy. We are talking about those cases where we feel that a woman is going to die during pregnancy and that risk of death can be ameliorated by ending her pregnancy. So serious medical disorder where we believe death will result. And again, with the issue of suicide, nobody is suggesting that suicide or that termination of pregnancy is a cure for the mental anguish, for the disorders that are associated